Okay, I'm muted, but we're on. I'm muted, but we're on.
You're not muted.
Oh, I will mute.
Welcome, everybody. We have folks joining us. We'll wait just another minute here before we get started. Okay, we'll get started here. Thanks for joining us. My name is Eric Hauge, he, him pronouns. I'm the executive director of Homeline. And usually you have Rachel Sterling, our communications coordinator and housing attorney. But instead today you have me instead. So hopefully I won't screw too many things up. But for those of you folks who are joining us for the first time, just a couple logistical things, and then we'll get to the main part of our presentation. Today, again, my name is Eric Hauge. I'm the executive director of Homeline. Today we have with us housing attorney Samuel Spade and policy attorney Larry McDonough, who will be discussing the new pre-eviction notice state law that goes into effect next year. Homeline, for those of you who haven't joined us before, we're a statewide nonprofit organization. We provide free legal advice to renters throughout the state and advised over 300,000 since opening. We advise renters in English, Spanish, and Somali and Hmong languages via our free and confidential hotline. And we have a staff of over 20 that includes housing attorneys, advocates, language-specific staff, organizers, policy folks, and others. There's our tenant hotline. We do get a lot of questions during these webinars, and we encourage you to ask questions about today's topic. We also get a lot of very specific questions from folks, from renters, and we'll try to answer questions generally, but for questions that are very specific to your situation, we want to make sure that we can answer your question the best possible and keep it confidential. So please, if you do have any questions about any tenant landlord situation and you're a renter in Minnesota, there's our contact information, or you can email us online. Today's session is being recorded and will be up on our website, hopefully within the next day or so, as well as the slides and the PDF of the slides. We do want to encourage you to, if you do have questions, use the Q&A system via Zoom. It's just easier for us to logistically to handle questions that way rather than in the chat. I will be putting some relevant links in the chat as well throughout the session. And we will be applying for 1.5 general CLE credits, and we'll let folks know once that's approved for Minnesota attorneys. And then just a reminder, this is one part of our multi-month series of webinars that are specific to the new laws that were passed by the 2023 during the 2023 legislative session. I'll put some links in the chat to previous recordings, but in the next upcoming months, these are the topics. In October, heat, emergency repairs, privacy, break lease due to infirmity. We'll be talking about evictions, expungements in November, the right to counsel in public housing, and various changes to the court eviction process in December. And then there are changes to the Minnesota renters credit that go into effect in the future. We'll be talking about those in January. Again, most of the laws that we've already touched on and that are coming up on these future webinars do go into effect in January of 2024. And then very importantly, we also have a full day CLE that will be designed for Minnesota attorneys that will cover all of the new laws, all of the new tenant landlord laws that that go into effect next year, and some others. And that is coming up on December 7th, and we'll be sending out information about registration for that soon. Again, in the chat, I will put links to registration for those future webinars as well as some other materials. But for now, we will, in just a moment, move on to our presentation. Again, want to remind folks to use the Q&A system for questions. We did get some questions in advance. We'll leave the Samuel and Larry to present for the next hour, or maybe a little bit less than that, and save most of the questions for the end. So, but feel free to submit them via the Q&A system. We'll get to them at the end. With that, I'm going to hand it over to Samuel and Larry to begin the presentation. Thanks, gentlemen.
Hello, everyone. My name is Samuel Spade. I'm one of the staff attorneys at Homeline. I'm also Homeline's Impact Litigation and Research Director. Eric, can I advance the slides or do you advance the slides? There we go. So we're going to start this presentation by talking about the current laws in Minnesota that relate to pre-eviction notices. And we're doing this for a couple of reasons. First, there are actually a lot of places, different areas of landlord-tenant, residential landlord-tenant law that have some type of pre-eviction notice already. And it's important to know what those are because those are currently in effect right now. If you were to file an eviction as a landlord, or if you receive an eviction as a tenant, you should be getting these types of notices or giving these types of notices. And it's also important because even though the new law will go into effect on January 1st of next year, like Eric said, and we're going to spend most of our time in this presentation talking about that new law, the new law is not going to completely change the existing laws. Many of these existing laws will persist in various ways. And so it's important to have an understanding of both as we go forward. But with that, let's actually start talking about the current laws. So first and foremost, there is no state law currently that requires a pre-eviction notice for either non-payment of rent or breach of lease evictions in Minnesota. That covers a lot of tenancies, residential tenancies, but there are many exceptions. So for example, 3 cities have ordinances, Brooklyn Center, Minneapolis, and St. Louis Park, and we're going to talk about each of those in depth. Manufactured homes also have exceptions to the rule, or I should say their own rule, not an exception to the rule, but they have their own rule. And then there are also rules for federal subsidies and the CARES Act, which we will cover as well. But let's move on to the cities. So starting with Brooklyn Center, because it has the longest notice requirement, you can see the city ordinance citations in parentheses after the city name. The Brooklyn Center ordinance is a pre-eviction notice requirement of 30 days for non-payment of rent and breach of lease. So for both non-payment of rent and breach of lease, the landlord has to provide the tenant with a written notice saying a couple of different things. For non-payment, they have to say the name, the mailing address, telephone number of the person authorized to receive the rent and fees, the total amount due, an accounting of how that amount was come up with, and the deadline by which the tenant has to pay it. So the tenant has those 30 days to either come up with the rent through financial assistance or what have you, or move, or if they are in the right, figure out how to present a legal defense, negotiate with the landlord. And this is often the case. Landlords sometimes send notices incorrectly. It's unfortunate, but landlords are people too. They don't always do the correct accounting. So often tenants will have some type of legal defense where they can use this time to prepare. But Brooklyn Center also has a 30-day notice requirement for material breaches of lease. Again, the landlord has to give a written notice, the name and address of the telephone number of the owner, describing the conduct that was the breach of the lease, and then basically tell the tenant that they have 30 days to stop breaching the lease. And if the tenant stops breaching the lease within those 30 days, the tenant can avoid an eviction. Or if the tenant believes that they are not actually breaching the lease or something like that, again, they can figure out how to present a legal defense within that time period. Now, the very important thing with Brooklyn Center's ordinance is that it does not apply to all residential tenancies in Brooklyn Center. It applies only to affordable housing units. Affordable housing units are units in an affordable housing building, which Brooklyn Center defines in its ordinances as 3 or more units within a certain rent cap. And I actually have to look at the statute because I don't have it memorized, but it is, let's see, affordable to the households at or below 80% of the area median income as determined by the United States Department of Housing and Urban Development, or HUD. So it doesn't apply to everything. It applies to certain rental properties, which is the majority, to my understanding, in Brooklyn Center. But if you rent a single family home or a duplex in Brooklyn Center, it won't apply. And even some apartment complexes might not apply if the rent is high enough. So 30 days for non-payment or breach of lease, but not for everyone in Brooklyn Center. Minneapolis has a city ordinance as well. Again, you can see this city ordinance citation there. It applies to all residential tenants, but it is only 14 days and only for non-payment of rent. Again, it has to be in writing. I guess that maybe goes without saying for these pre-eviction notices, but it's a written pre-eviction notice that has very similar requirements. The total amount due, an accounting of how much or how that amount was come up with, the name and address of the person authorized to receive the rent, description of how to access legal and financial assistance, and state that the owner can or may bring an eviction action if the tenant doesn't pay. Again, giving that tenant time to seek financial assistance, move, come to a payment plan, present a legal defense, etc. St. Louis Park, similar to Minneapolis, is it's applicable to all residential tenants, but it's only 7 days. It's only 7 days, and it has slightly fewer requirements for the written notice. It still requires the total amount due and an accounting, as well as a name and address, but it doesn't have exactly the same requirements as Brooklyn Center and Minneapolis or the new state law. So those are the 3 city ordinances, and it looks like we are posting links to them in the chat as well, so you can read the actual ordinance. But from there, now let's talk about manufactured homes. So manufactured homes or mobile homes have an entirely different section or chapter of state law that apply to them. Regular residential landlord-tenant law in Chapter 504B applies to them, as does most case law, but they have an entirely new chapter or additional chapter, 327C, that provides additional requirements when the tenant owns the manufactured home or mobile home and rents the lot. Specifically, they have essentially an endless lease. The tenant can never be required to sign a new lease for the duration of their time in the mobile home park. That lease that they have when they start goes forever. There's some rules about how frequently and how often and in what types of rule changes the landlord can impose, as well as rent increases, but the lease itself exists, again, essentially forever. It can't be changed. So there are some notice requirements before the landlord can file an eviction, because the only way the landlord can kick a tenant in a mobile home park out is by filing an eviction. And they can only do so for certain reasons. There's a 10-day notice requirement for non-payment of rent. I should have this up in front of me. Give me one moment. Because it has not that many requirements, but it has a very specific one, which is going to persist. And that is that the park owner has to give a 10-day written notice to the resident and to any party holding a security interest in the resident's home. So sometimes the park owner may not, the tenant owns a home, but maybe the tenant is in some way renting from the home from someone else, or buying the home from someone else, or someone has a lien or mortgage on the home or something similar. The park owner has to give 10 days written notice, not only to the resident, but also to anyone holding the security interest on the home. There's a 30-day notice for rule violation. So this is a breach of lease. If the landlord is going to say you are breaching the lease in a manufactured home park, they have to tell the tenant 30 days notice, just like in Brooklyn Center, give the tenant a chance to cure or stop the violation, not be evicted. The same is true for endangerment, except that in some cases, the tenant won't have any right to cure if the breach is bad enough. If it endangers the resident or park personnel, causes substantial damage, there might not be the ability to cure, though the tenant still gets notice. So really the only way there's no notice in a mobile home park is if there are many violations or the notice has already been given and expired in some case. So those are the notice requirements for manufactured home parks. And at this point, I'm going to turn it over to Larry to talk about subsidies and the CARES Act.
Yeah, thanks, Samuel. So part of the reason we're going to talk about the reason why, and to echo what Samuel was saying, the reason we're talking about the current law is that the new law is going to overlap with many of our current laws in terms, and so we'll be looking at kind of matching the kind of compatible requirements. And so we need to do that regarding federal law as well, because that same kind of overlapping is going to happen. And so before the CARES Act, and I'll talk about that in a moment, the CARES Act was enacted in the summer of 2020. Various public and subsidized housing programs, unfortunately, have a lot of requirements that are just different. And so if you're going to practice in that area, if you're a landlord in that area and you need to know which program you operate under, if you're a tenant, you need to know which one is governing you as well. And sometimes that's a little hard to figure out. Sometimes it's relatively easy. But the timing and notice requirements vary based on the type of the subsidy program. And same with the notice content. So let me just go through a few of those, and then I'll tell you where you can find out more information. So the one that's probably most widely known among landlords and tenants is a Section 8 voucher program. This is a program where a subsidy, once a tenant achieves the possession of that subsidy voucher, and there's no longer really a physical voucher that anybody gets, but that's what it's called. Then that tenant goes around to the landlord community and applies and finds a landlord who is willing to participate in the program. And then the tenant and the landlord sign a lease. The tenant signs paperwork with the Section 8 office, and the landlord signs what's called a housing assistance payment with the Section 8 office. And Section 8 office may be part of a public housing authority program like Minneapolis Public Housing Authority, or it might be another similarly but differently named entity like the Metropolitan Council Housing and Redevelopment Authority, often referred to as Metro HRA. So in this program, this is the program that's probably the most like private housing that's not subsidized. And that was part of the way the program was created. And so because of that, landlords do not have an obligation to give a notice before filing an eviction case before the CARES Act. So now we're talking in this time period before the summer of 2020, and that changed with the CARES Act. So if the rent was due on the 1st and the tenant didn't pay the rent on the 1st, the landlord could file a case in the 2nd without having to do a pre-eviction notice. Now, these requirements vary a lot among the different programs. So public housing, on the other end, that's a program in which the housing is owned by a government entity, like a public housing authority. So some public housing authorities manage a Section 8 voucher program and rent and manage their own subsidized housing program called public housing that the government owns. And there's a different set of notice requirements there. So there is an actual notice requirement that the public housing authority has to give. And then in some cases, the tenant can request a meeting with the public housing authority to discuss it. And in some cases can request an administrative hearing to contest the contents of the notice. And the public housing regulations have a lot of language about what goes into that notice. So in between the less regulated voucher program and the more regulated public housing authority, or the more regulated public housing, you have kind of a myriad of different types of subsidy programs. And in public housing and these other subsidy programs, other than the Section 8 voucher, the subsidy is tied to the unit. So if the tenant moves, the subsidy stays with the unit. Section 8 voucher program, the reason why it's popular with tenants is If the tenant's not evicted but wants to move, the tenant can take that voucher subsidy to another landlord willing to participate in the program. So when you look at these other project-based housing programs, they are owned and operated by private landlords. They are getting contracts from the federal government, but the subsidies stay with the unit. And there, the notice requirements vary a lot from program to program. The most common program is what we call project-based Section 8. And there, the landlord would have to give a minimum 10-day notice, and in some situations, a 30-day notice, and the tenant has the right to request a meeting with management to discuss it. And so it's kind of beyond the scope of this to go into any more detail on public and subsidized housing programs. I have a manual called Residential Eviction Defense and Tenant Claims in Minnesota. There's a link to that here. It's housed on a website called povertylaw.homestead.com under housing. So next slide, please. So that was all just, unfortunately, background for the CARES Act. So the CARES Act, you may have heard of this because it was the law that was passed in really the early days of the pandemic. It had an eviction suspension for certain properties for non-payment of rent in the summer of 2020. You might remember hearing about enhanced unemployment compensation benefits in that time period. That was part of this act. So why do we care about this now? Well, part of that act has, evaporated. It's kind of gone past its tenure. So like we don't have that eviction suspension anymore. We also don't have the enhanced unemployment compensation benefits. But there is a provision that was in effect at that time and has not expired. And so that's a provision that requires owners or what are called covered properties to give a 30-day notice for eviction. And so this 30-day notice period essentially overrides the shorter notice periods that you have in some of the subsidized and public housing programs. All of the public and subsidized housing programs that are administered by HUD that require a notice in a rent case, the notice requirement is less than 30 days. So what the CARES Act is extended that notice period to a longer time period to 30 days, but did not override the content requirements of the subsidized housing notices. So for instance, public housing notice, there are a number of just words that have to be in that notice, but now it's a 30-day notice with those words. So there's been litigation about this act in Minnesota. A number of landlords have argued that, well, it must have expired when the eviction suspension expired. All the court decisions I've seen have rejected that argument, both here and around the country. And I think those are right because the eviction suspension had a time period in it, and the notice requirement was not limited to a time period and did not have expiration language in it. There also have been arguments that, well, the landlord could give the 30-day notice, but then file the case right away. And as long as the court didn't evict the person within the 30-day time frame, they will have complied with the law. And I have not seen any court decisions accept that argument either. So we don't have a Minnesota Supreme Court decision on this. There are several appellate decisions around the country. There are district court decisions in Minnesota and elsewhere around the country. I have a discussion of that at a different section in my manual, Residential Eviction Defense and Tenant Claims in Minnesota. So now I will pass it back to Samuel to give us an overview of the new law. Well, first problems and then solutions.
Yes, thank you, Eric. So I am going to cover the overview of the new statute. But before I do that, I want to talk briefly about why Homeline and many other people supported this new statute. And we have supported many of the ordinances as well in the cities. And then the CARES Act or I should say the mobile home one predates Homeline. But we supported this, as did many other people, because evictions are serious and they harm everyone. And when I say everyone, I do in fact mean everyone. I don't just mean the tenant who has a court case that could cost them their housing. It includes their tenant's family. It includes the landlord, though, because landlords are in the business of collecting rent. Morality aside of anything that any side of this argument might say, as it currently stands, the business of being a landlord is it makes a profit by collecting rent from people who are living in the building, not from evicting people. Evicting people does not get the landlord money. It costs the landlord money as well. And there is ultimately also a harm to society as a whole. Evictions have worse health. People who are evicted, especially people who face homelessness, have worse health outcomes, worse education outcomes. There are many things that are significantly negative to them, to their families, to the people around them, and that slowly affects all of us, regardless of whether we are landlords or tenants, whether or not we have been evicted or anything along those lines. It eventually just spills out into all of our society. So evictions are serious. They harm everyone. Also, and this is closer to my personal opinion, though I think Homeline would support me here, tenants have a right to have notice. They should have a right to have notice. If you own a home and you fall behind on your mortgage, you get months and months before you lose your home. In fact, the entire process probably takes over a year. And so saying that tenants should have the right to 2 weeks of notice before the eviction is, in my opinion, the bare minimum. I personally think they should have more. I really applaud cities like Brooklyn Center that have 30 days notice. I think you see this also with the federal subsidies and the CARES Act. 30 days notice is pretty common. Tenants should have the right to have notice. And finally, part of the reason they should have a right to have notice is, again, because lack of time means lack of options. It is very difficult to get emergency assistance immediately. In fact, I would say it's pretty much impossible to get emergency assistance immediately. It's still difficult to get it within 2 weeks. 2 weeks is not really fast enough most of the time. It will be some of the time, but not all of the time. There are some other changes to the law that Larry will discuss in greater detail that do help with this a bit. But even so, 14 days is a very short period of time to get emergency assistance. But it is more time, and it will allow more people to get emergency assistance and pay their rent, which again, that's how the landlord makes money, collecting rent from the tenant. So it's good for them as well. And it's also difficult to move because in some cases, tenants simply will not be able to pay the rent. And under the current system that we have legally, this means that they will have to move. And it is easier for a tenant to find a place and maybe even to avoid the eviction for everyone, for the landlord as well. So hopefully that will at least convince some of you that there are benefits to all parties here, tenants, landlords, the court system, society as a whole, with providing tenants with notice. And with that, let's talk about the actual notice requirement. So this is the new law. It will be mostly changes to, let me make sure I get this right, 504B as in boy, 0.321. Currently, you can get it in our session law, or in the Minnesota, sorry, there we go. There's the link right there. I'm not going to read it out. It's effective January 1st, 2024. And it will require a number of different things. First, it will require a 14-day notice for non-payment of rent. So again, we've been going back and forth talking about non-payment of rent and breach of lease. This requirement is only going to be for non-payment of rent, not breach of lease. The 14-day notice for non-payment of rent. It will apply to all residential tenancies. It has to be hand-delivered, so directly handed to the tenant, or sent by first-class mail. Then there's also a number of elements to this notice that have to be included for it to be a valid notice. Like we talked about with the city ordinances, it has to include the total amount due. It has to include a specific accounting of the amount, how they came up with that, and break down whether it's unpaid rent, late fees, or other charges under the lease. This is a very big deal for tenants. Tenants need to know where their fees are coming from. If they don't know, it can be difficult to dispute, to figure out whether or not these charges are even accurate, because sometimes they aren't. So it has to break down the fees. It has to give the name and address of the person authorized to receive rent and fees on behalf of the landlord. Again, the tenant has to be told, this is how you pay your rent. This is who you pay your rent to. And there's a couple other things. Next slide. So it has to have about 3 specific phrases, and these are in quotes because the statute does actually require this language or something very similar. It has to say that they have the right to seek legal help if they can't afford a lawyer. Free legal advice might be available. It has to tell them about financial assistance and provide some of those phone numbers. And most importantly, in some sense, it has to tell the tenant that this is actually a risk of an eviction, that if they don't pay the notice or the rent within the time period, the landlord may file an eviction action. Now, it's worth pointing out the landlord doesn't have to file it within 14 days. They also don't have to give this notice on day 2. If rent is due on the 1st, there's no requirement that the landlord give this notice on the 2nd. They can wait 5 days. They could wait 10 days. They could wait longer. But they can give this notice as soon as rent is late. They could give this notice in this form. And if they don't, that will provide a number of different defenses to the tenant, which I will turn it back over to Larry to talk about.
Okay, so first of all, the most obvious defense is with the language that's in the statute. And quote, the court must dismiss and expunge the record of any action if the person bringing the action fails to comply with this section. So there are a number of ways one could fail to comply with this section. And this statute covers more than just the notice. It covers the content of the eviction action complaint and other issues. But this sentence applies to the whole statute. So in terms of the notice, if the landlord doesn't give the notice at all, that would clearly be a failure to comply with this section. If the landlord gave the notice but didn't include the quoted language from the last slide, I think that's certainly a failure to comply. And you notice that the sentence doesn't have qualifying language like fails to materially comply or significantly comply. It doesn't have kind of a de minimis kind of exception. So I have been a landlord off and on over the years. I'm not presently a landlord. What I would do is just make it part of my practice, and I have people working for me, train them in that when we do eviction, when someone is behind on the rent, beginning in January 1, 2024, this is the new notice that we're going to be using, and it's got to include this language in it, and it's got to be delivered to the tenant in compliance with the statute. But when I've talked to landlords and tenants over the years about eviction cases, and they're focused on a particular issue, I always remind them, don't forget everything else that's relevant to evictions. So in the area of non-payment of rent, there are many other defenses besides just looking at whether the landlord complied with the notice. And if you're a landlord, you have to be thinking about, is the tenant going to have some defenses, and how am I going to prove up my case? And so some of the issues that come up in a non-payment of rent eviction case certainly can come up. Is first of all, when the complaint is and summons is served on the tenant, is it done the right way? If you're the landlord, you want to make sure it's done the right way, because if you don't, the court is supposed to dismiss the case for not having jurisdiction. In other words, not having power to do anything for the landlord and against the tenant if it doesn't have jurisdiction. And the way that the court obtains jurisdiction is by how the landlord gets the court papers to the tenant, and the person who does it, and the method. Okay, it's beyond the scope of this seminar to get into the details of that and some of these other defenses, but I just want to remind people of them. There are a number of preconditions that landlords have to satisfy. Some of them are related to the fact that they're a landlord, and some are related to the fact that they're a litigant. And so an example of one is landlords have an obligation to disclose contact information to tenants at the time that they file the lease. And if the tenant doesn't have address, contract information for the landlord, the court is supposed to dismiss the case. Probably the most common defense in a non-payment of rents case is the condition of the property. And the reason that's relevant, we have a law, 504B161, that requires landlords to maintain the property in compliance with housing codes and in a reasonable condition. And if they don't, and there's some other requirements in there as well. And as of January 1, 2024, a new requirement in that law is to maintain the temperature of 68 degrees over kind of the winter time period that's listed in that statute. When the landlord doesn't maintain the property in reasonable repair, the tenant has a defense that the landlord's not entitled to all of the rent. That's based on a Minnesota Supreme Court decision from the 1970s. So if you're a landlord, you want to make sure most landlords do maintain their properties. I always did when I was, because you want the property you appreciate. But, if you are considering a non-payment rent eviction case, you ought to be giving some thought to, is there a potential defense here for repair problems? And if you're a tenant, that's one of the things you want to consider, even if you didn't withhold your rent because of repair problems. You get to raise that issue regardless of whether that was your intent in being behind in the rent. We have a law that regulates late fees. They have to be less than 8% of what is owed on the rent. We have laws governing billing for utilities, and they can be a little complicated when you're using things like shared meters, having a single meter that covers a number of units and dividing up the bill amongst the tenants. There are a number of requirements there, and failure to comply with those requirements can be a defense. Another defense is retaliation. That one is not raised often in non-payment of rent cases, but it is a defense that can be raised. And there are other defenses as well. And I outline a lot of those in my manual on the poverty law website. Next slide, please.
Larry, if I may
Sure.
ask a quick question here. I think
Yeah.
it might go without saying, especially to us attorneys, but when we talk about a defense, we're talking about dismissing the case, the tenant actually winning, not having to move. And I know that this law is new and has not yet gone into effect, but we have other notice requirements that have existed for a while. Can you just talk about how courts generally handle that? What happens in a case when a tenant raises one of these defenses?
Yeah, so one of the things that's important about this law, if we back up one slide, is that this law differs than others in that it has specific language that says that if the court must dismiss and expunge if the notice is not compliant. And a lot of the other laws and regulations governing notices don't have that explicit language there. But even without that language, it's quite common for courts to dismiss an eviction case for non-compliance with a failure to comply with the notice requirement. And the thinking behind that is, if you have a requirement to give a certain kind of notice and it has a certain type of content and a certain time frame, and then that it's the giving of that notice that gives you the right to file the case, it kind of makes sense that if you don't give the right kind of notice, you haven't satisfied that precondition to have filed the case in the first place. And so that's kind of the logic behind dismissing cases when the notices are inadequate. But here we have specific language on that. Now, when we get to other defenses, sometimes the defense results in a dismissal, but sometimes the defense is just relevant to a trial. So if the court papers are served the wrong way, that's probably going to lead to a dismissal because the court's going to conclude, I don't have jurisdiction to handle this case, so I'm not going to go any further on it. Now, when you get to an issue like the tenant saying, yeah, I owe some rent, but the property is substandard in terms of repairs, that's not going to lead to a dismissal. It's going to lead to a trial on the issue of, one, what does the tenant owe? And that would always be an issue in a trial for non-payment of rent, unless the tenant concedes owing the amount that the landlord says. If the tenant's raising the habitability issue, then the tenant basically puts on a case, has to prove beyond a preponderance of the evidence that the condition of the property is substandard as compared with our state statute or local ordinances on the effect. And then the court would basically kind of analyze that evidence and make a decision about either the property's in good shape, and so the landlord's entitled to the rent, it's in bad shape, the tenant's entitled to some of the rent back, or in an extreme situation, the property is in such bad condition that the tenant gets all the rent back because it's essentially uninhabitable.
Mm-hmm. And so what you're talking about from the legal perspective is dismissing with or without prejudice, essentially whether or not the landlord can refile it. And in the Fritz defense that you were just discussing, the tenant is winning in such a way that the landlord can't refile or rebring the claim, can't try to evict the tenant for that issue. For service or even this notice, failing to give this notice, the landlord could refile, but they do, in the notice case, have to actually then give the notice, wait the required amount of time, and then refile the court case for non-payment of rent.
Right. And so what Samuel's getting at is a kind of the distinction between, you've probably all heard of the concept of double jeopardy. And basically what that means is you can't do, if you receive a judgment on the merits of your case and you lose it, you can't file the identical case again and basically subject a defendant to having to defend the same case on the merits a second time. So that's what double jeopardy is. And you hear about that in kind of the criminal law setting as well. You can't be, if the prosecution loses a case against you for a particular crime, they can't just file the exact same case again. They got to file something different. Now, when a case is dismissed for either bad notice or bad service of the court papers, you never get to a judgment on the merits, because the court is saying this case is flawed essentially procedurally, and I'm not going to move forward with it. And so that would lead to what we call a dismissal without prejudice. That means the plaintiff can file that case again, but they need to fix the things they got wrong the first time. So it might mean if you gave the wrong kind of notice, you do a new notice. If you serve the court papers the wrong way, you figure out how to serve them the right way, and then you can file the same substantive case. You could file that same non-payment of rent case again. And so a dismissal with prejudice, which I often feel like is kind of the wrong way a judgment on the merits ought to be characterized. I think it ought to be characterized as judgment for tenant as opposed to dismissal of landlord's case. But essentially, they, in a practical sense, they mean the same thing, that a dismissal with prejudice is really like a judgment on the merits. Okay, let's go to the next slide. So Samuel talked a little bit earlier about the issue with emergency assistance. And the language in this statute, I think, is going to be really helpful to landlords and tenants. Samuel talked about how there's, even though emergency assistance program, you'd think with the word emergency ought to operate really quickly. Unfortunately, it's been our experience that some emergency assistance programs have not operated that quickly. Some have and some haven't. And so we saw a lot of problems over the years that were hurting both landlords and tenants, because let's say the landlord likes the tenant, tenant likes the landlord, but the tenants, lost some hours at work, they got behind on the rent, they're not at each other's throats, but the landlord realizes that, well, I can't do this without getting the rent. And so they might even reluctantly say, okay, I got to file this eviction case against you. Tenant goes to emergency assistance, and emergency assistance says, well, we need some verification from the landlord that you actually owe what you're saying you owe. And we had problems with some agencies where the tenant brings the court complaint in. It says, court complaint says I owe $1,000. And well, we still need the landlord to fill out this verification form. And maybe it goes out quickly and maybe it doesn't. And so there have been a lot of cases over the years where the tenant didn't get the emergency assistance in time, and the landlord was unwilling to wait for an indefinite period of time to get it. And so one of the things we really wanted in this law was something that would essentially expedite, I would say, a program that already should have been expedited. And so these two requirements are, in my view, a really big deal. That the notice to the tenant before the landlord even files the case now, the notice to the tenant is essentially the verification of the emergency and essentially the verification of the amount needed. And that the agency can't ask the tenant for more verification other than the notice. And the tenant can't ask the landlord for essentially a verification or an agreement that the landlord would accept the funds. And so we're really hopeful that these elements here will mean that when the tenant comes to emergency assistance with that notice, then it's more a matter of figuring out if the tenant is eligible based on, you know, their income and their household size, and then cut a check. And so our hope is that this new law, well, this part of this new law will expedite the payment of money. But the other thing that Samuel was mentioning is that the fact that there now needs to be this 14-day notice, which I would say is a little bit like a cooling off period in kind of the labor strike world, where it will allow the tenant and maybe push the tenant and the landlord to talk a little bit about what can be done to avoid the eviction in terms of either paying the money, doing a payment plan, moving out, going to emergency assistance, now with these requirements that will help, hopefully help emergency assistance go quicker. I mean, my view is that this law could lead to less evictions. And I know there are landlords that have not liked having this requirement there coming up. I can say that, as we discussed earlier, there are a lot of landlords that already have had to comply with a pre-eviction notice requirement for non-payment of rent, like manufactured home park lot owners. They've had to give that notice in Minnesota. The different subsidized housing programs like project-based Section 8, public housing, they've had to give that notice too. And it's not like those industries have just evaporated because they couldn't deal with the financial strain of waiting a week or two before they file the case. So there's a lot of history around. I mean, the manufactured home park law has been around for a long time. These subsidized housing programs have been around for a long time, and their requirements. And those industries have not gone under because they had to give a notice before filing in a case. And in my experience, as a tenant advocate, you know, when tenants have gotten notices saying that a case might happen at this point in time, if something isn't done, it's led to resolutions that don't result in that case. Now, sometimes they do result in the case. I'm not going to say evictions are going to go away, but I think evictions for non-payment of rent in Minnesota are going to decrease. Next slide. Okay, another part of the new laws, but not in the section we've just been discussing, is in so a different section. And it makes clear that, so let me talk about the concept of redemption. So just so you know, we're talking about legal redemption, not kind of religious redemption. Redemption is a concept in Minnesota law that says that the landlord files an eviction for non-payment of rent against a tenant, that is essentially a demand for the rent. And the tenant can respond to that demand by curing whatever the court says the tenant owes within the time frame that the court gives a tenant. So, you know, let's say I'm the tenant and I'm in court today, and the court decides, okay, McDonough, you owe $1,000. Can I have some time to pay the rent? And the court, if it's a lot of money, like $10,000, maybe the court's going to say no. But it has that power to say, yeah, I'm going to give you some extra time. I'm going to give you 10 days to do that. And if I pay what the court says I owe within the time frame the court gives me, then I have redeemed the tenancy. In other words, I've made the landlord whole, and therefore I don't have to move. Now, a lot of times a redemption will include more than the rent, because the landlord could say, well, I did have to pay my filing fee, and there was a late fee here. And so the court can say, okay, McDonough, you owe this $1,000 rent, and you owe this $80 late fee, 8%, and you owe the landlord's $300 filing fee. And so if you want to stay, in 10 days, you got to pay the $1,000 and the $300 and the $80, so $1,380. If you pay that, you get to stay. Now, courts have varied a little bit around the state in whether they would accept a guarantee from a nonprofit or an emergency assistance provider saying, we've got the money, we can pay the money, we won't have it for McDonough in 10 days, but we'll have it in 20. And some courts have said, okay, that's good enough. We're gonna wait the 20. Others have said there's no law that says we have to do this, and I don't want to make the landlord wait any longer, so I'm not going to do it. And so what this does is it essentially says that a guarantee from that agency does satisfy a redemption. So when this goes into effect in January 1, 2024, and I come to the court with this guarantee, then what the court's going to do is say, okay, we're going to allow this agency the time that it says it has to do that. And we'll just have to see how that plays out. This is a new required concept. And hopefully this will help both landlords and tenants. Because if the difference between the landlord getting paid in 5 days versus 10 days and whole for everything that they're owed, that helps the tenant out, it helps the landlord out as well. I mean, the landlord's getting paid and they're getting reimbursed for their expense for having filed the case, and they don't have to go find a new tenant to move in. So I'm optimistic that what we just talked about in the last slide is going to lead to lower eviction case filings. What we're talking about in this slide, I think, might lead, in cases that have been filed, might lead to less actual removals of tenants, because they'll be able to use this guarantee to get the time it takes to pay the landlord and stay. Next slide. So with all that being said, I mean, we've talked a lot about current laws and we've talked about new laws. How is all this stuff kind of rolled together at this point? So let's start with the ordinances. So we've got the Minneapolis ordinance. That's a 14-day requirement. So that's the same as the state law. But the language in the Minneapolis ordinance and the state law are not identical, okay? And so if I were a landlord in Minneapolis, I would look at the required language of the Minneapolis ordinance, the required language of this new law, and you've got some time to do that. The new law doesn't go into effect for a number of months, and come up with a notice that satisfies both of those laws. Now, if you're in Brooklyn Center, you've got the longer notice, okay, the 30-day notice, but you still have content requirements there. So if you're landlord in Brooklyn Center, you want to make sure that your notice as of January 1, and hopefully you've already got a notice that satisfies what you've got in Brooklyn Center. So tweak that notice so that you've got the content of both Brooklyn Center ordinance and the state law, but because it's Brooklyn Center, going to need to give the 30-day notice, not the 14-day notice. This is going to be kind of a consistent theme on this slide, is we're kind of overlapping kind of the longest time frame with the content of whatever laws apply. Let's move on to St. Louis Park. St. Louis Park has 7 days. So now in St. Louis Park, that notice is going from 7 to 14. But again, you want to make sure your notice includes the St. Louis Park content and the state content. And if you're on the defensive side, you want to look, if I'm an attorney and I've got an eviction case in Brooklyn Center in February of 2024 for non-payment of rent, I'm going to look at that notice and I'm going to compare that notice with the Brooklyn Center ordinance and with the state law and see if it's compliant. If it's not compliant, then I'm going to make a request to the court to dismiss the case. If you're on the landlord side, you want to make sure that I don't get to do that. Now, when you're looking at manufactured home parks, this is getting a little more complicated because now we got one law in the mobile home or the manufactured home park law that says we've got a notice requirement. It doesn't say a lot about content. It says a little bit about content. Samuel talked about that earlier, that it has to it talks less about content, but it says that you got to give a 10-day notice, and then you got to give it to the party holding a security interest. So a security interest would be if you got a loan from a bank to pay for the manufactured home park, or for your manufactured home, then it needs to be notified of that the landlord's given this notice. Okay, so that's the existing law, is a 10-day notice there. Okay, but now we have, and that's a state law. Now we have this other state law saying it's a 14-day notice. The reason why it's a little more complicated is, these are both laws from the same entity, the state of Minnesota. When we're talking about the ordinances, there's no confusion that a state law is higher up on the food chain than a local ordinance. And so it clearly overrides parts of the ordinances that are inconsistent. Okay, so how do we deal with the fact that we've got 2 different state laws that kind of are inconsistent? Okay, and without going too far down the rabbit hole of that, we actually have laws. For those of you who aren't attorneys, you might find it interesting that we have laws about how to interpret laws. Okay, and they're called kind of canons of construction. And one of those is 645.26, which deals with irreconcilable provisions in laws. And one of those provisions is that subdivision 4, when provisions of 2 or more laws passed at different sessions of the legislature are irreconcilable, the law latest in date of final enactment shall prevail. So I think because of that, if this issue gets litigated at all, I think the courts are going to say, well, this 2023 law that covers notices to tenants, and tenants are defined in state law in 504B001 as including residence manufactured home parks. Okay, so I think the courts are going to say, manufactured home parks, you now have to give a 14-day notice instead of a 10-day notice. You've got to include all the content of the new law with a 14-day notice. But you also have to remember under the manufactured home park law, you got to send that notice to the party with the security interest. Okay? So if I was managing a manufactured home park, even though this isn't a change to that manufactured home park chapter, I would say, okay, I'm going to develop a notice that's different than the notice I have been using, that complies with the state law, and also includes 14 days, and I give it to the party holding the security interest. Okay. Now, if it's a manufactured home park in, let's say, Brooklyn Center, then you've got to also make sure that your notice complies with the Brooklyn Center ordinance. Okay, so now on to the federal stuff. Federal subsidies, as we talked about earlier, the content still applies, but the new law, content of the new law also must be included. But because of the CARES Act, it's got to be a 30-day notice. So if you have a project-based subsidized unit, and let's say you're not in Minneapolis, Brooklyn Center, or St. Louis Park, then your notice has to be a 30-day notice, but have the content from the new law in it that we've discussed earlier, including those quoted sections. If you are in, let's say, St. Louis Park, then you, just like we talked about earlier, you'd need a 30-day notice under the CARES Act if you're federal subsidy. You'd have the content of the new state law, but also the content of the city under its notice provision. Then finally, what some people forget is the CARES Act not only covered public and subsidized housing properties, but also properties with federally backed mortgages, okay? So if a landlord has a federally backed mortgage, it's got to give a 30-day notice under the CARES Act, okay? So I don't know if I have a federally backed mortgage. I've been in this house for almost 20 years, but I don't rent it out, and my mortgage has changed a whole bunch of times. But if I were a landlord, if I were renting out a room in this space to somebody, I'd need to figure out if I have a federally backed mortgage, because if I do, then I got to give a 30-day notice. If I don't, then I have to give a 14-day notice, because without the CARES Act, then we're back just looking at the state law, the 14-day notice requirement. So I get that this is going to be challenging for landlords to kind of look at this whole overlapping. And unfortunately, you know, for better or worse, being a landlord is working in a regulated industry. And and you can dislike it as much as you want, but it is the reality. And so you need to accept it. And I think it's good that it's a regulated industry, because people, tenants that have shelter in rental housing, they can be a vulnerable class of people. So it needs to be a regulated industry. But what you're going to have to do if you're a landlord over the next few months is figure out what's the length of notice I'm going to have to give? Is it 30 days or is it 14 days, depending on whether you're covered by the CARES Act or not? And then what kind of content do you have to have? If you're not in a city with a local ordinance on it, then your content is simply what we've got in the new state law. If you're in one of the cities that we've mentioned here, then your content needs to satisfy both the city requirement and the state requirement. So I spent a bit of time on this slide because I think this is the part that's maybe the most kind of confusing at first glance. But I think once you kind of wrap your head around it and just figure out this is the kind of notice I'm going to have to do, and you get it ready, and you've got time to do it if you're on the landlord side. Next slide.
Larry, one quick question here for
Yeah.
you. You were talking primarily about combining the notices, so that the landlord can give one notice that complies with all relevant ordinances. And it's worth pointing out that while there's a number of bullet points here, most landlords probably only have to comply with 2, maybe 3 if the CARES Act applies, because it's not like the property is not going to be in 3 different cities at the same time.
Yeah.
But I think that you would agree, although this is why I'm asking you, that you could also just give 2 notices. For example, if you were in St. Louis Park, you could give the 14-day notice under state law, and then 7 days later, you could give a 7-day notice under the city ordinance, and that would work as well. And for the CARES Act, the same thing could be true. You could give the 30 days CARES Act requirement, and then 14 days before actually filing the eviction, give a notice, the same notice required by the state ordinance.
Yeah, I agree with that. I think, you know, just probably from my own kind of notions of efficiency, I would probably be inclined to go with 1 notice. Because the more acts that you have to do to perfect a case, the more chances there are on the landlord side to mess it up. And so if I were running a property, I would say, you know, I want to have 1 notice that satisfies everything I need to satisfy. Now, for landlords that operate properties, you know, around the Twin Cities or around the state, you know, maybe it makes more sense to have multiple notices. I mean, if I'm a landlord who has a property in St. Louis Park and I've got another property in Golden Valley, I don't have to use the St. Louis Park language. So if I were doing, if that were the case, then maybe I have a 14-day notice that complies with the state law. And then I have a separate 7-day notice that complies with St. Louis Park. And when I'm giving a notice in St. Louis Park, I use both notices. And if I'm in Golden Valley, then I only use one. So that might be the argument for multiple notices. I'd probably, if it myself, I'd probably just say, here's the St. Louis Park notice that satisfies St. Louis Park and the state. And then I have a separate notice for my Golden Valley property that doesn't have the St. Louis Park stuff in it. Okay, next slide, please. So just a summary of what we've got here. So we now have a specific statewide 14-day notice that's required before filing an eviction for non-payment of rent. It's a defense to the eviction. And as we just discussed, some cities require more, like Brooklyn Center. The CARES Act requires more. And as you can see, there's this kind of a little bit mixing and matching of content. Next slide. So we're now ready for more questions.
All right. Thanks very much, Samuel and Larry, for the presentation. We've got about 25 minutes here, and we have some questions that were submitted in advance and quite a few in the Q&A here. So we're going to start with those that were submitted in advance. Some of this might be duplicative, but we'll ask the questions and answer them. And if we do have any time at the very end, we'll move on to other tenant landlord related questions that aren't specific to this topic, but we're going to try to focus on this topic. So first of all, Christina asked, is there certain or specific language that is required for the notice or a specific form?
At this,
Go ahead.
Sorry.
I'll answer that one. I'll answer that one since I started talking. So I think we covered that mostly in the slides. There is specific language that's required. There are not specific forms. So I'm not aware of any city or state that has put forward like a actual form that the landlord must use. They've just said, here are the things that must be in it. And in the case of the state law, here are some very specific statements that must be included as well.
Yeah, what I would add to that is, we have summarized the statute for you, but we have a link in the slide where you can go back and take a look at the actual language that's in the law that was passed in 2023 and see the elements are there. I mean, we basically have told you those elements in the slide, and where we've had quoted language, that's the specific language that you need to have. Now, how you want to phrase the word, the total amount due, you can play around with some language there. At this point, there aren't any forms. I don't expect the courts to develop a form. I wouldn't be surprised if some landlord advocacy groups put together a form. But keep in mind, if you're using the state, if someone gives you a form and says that it complies with the state law, since this is a very new law, I would compare the form to the law and see if you think it satisfies all the elements of it. But then keep in mind, if you're in one of the cities that has a notice requirement, you're going to have to make sure that your notice covers any differing language that the city has.
All right. I'm going to combine these two questions because they're somewhat similar. Christine asked, at any point or at what point would law enforcement potentially be involved? And there was another related question from Carrie. So eviction notices don't need to be delivered by a sheriff?
Well, I can take that one. Notices, law enforcement only gets involved with an eviction case if they are asked to deliver the court papers to the tenant. The type of law enforcement normally would be a sheriff's office, and they do charge for that. And then they have involvement at the end of the case if the landlord wins and the tenant is not moving right away, then the landlord has to get law enforcement to bring out a document called a writ of recovery. And if the tenant doesn't move, then the landlord asks the law enforcement to involuntarily move the tenant. Law enforcement generally is not involved with doing notices before the filing of a court case. And I'm guessing they would probably say, we got enough to do, we're not going to do that for you. So generally, landlords have management agents or other people associated with the property deliver those kinds of notices, and law enforcement only gets involved once a case has been filed.
All right, thank you. This is maybe more of a comment, but if you want to comment on it, Ruth sent this 14-day advance notice passed by the legislature doesn't really give enough time for tenants to secure rental assistance.
I can comment on that quickly. I mean, this is often true. It is not always true, but it is often true. Hopefully the emergency assistance, I know they're working to make their process faster. Hopefully they will succeed in doing so. And also, as Larry talked about, hopefully the requirements that this 14-day notice count for emergency assistance, and then also for redemption purposes, that a promise to pay is equivalent to paying. Hopefully that will help quite a bit as well.
All right. There was a question asked about similar city ordinances, and I think you all captured that very well, so we won't go into that in more detail. A question came in the chat when you were talking about the 327C manufactured homes. With manufactured homes, does this apply in Anoka County?
Yes, the 327C, that's Minnesota state law. It applies to manufactured homes anywhere in the state of Minnesota.
All right. Okay, and then jumping to some of the questions that came in here. So here's a question from Kim, maybe a little specific here, but if we terminate project-based HUD supported tenant effective in 90 days and they fail to move out, are we required to then do a second notice of an intent to evict, or can there be language in the termination that can include the eviction within that same 30-day notice?
Yeah, I'm a little confused by the question. First of all, did you say 90 days in the beginning of this question?
No, 30
30.
days. Apologies.
Okay. Well, the CARES Act doesn't have any content requirements in it. So if you've already given a 30-day notice, and again, the new Minnesota law doesn't go into effect until January, so that doesn't even apply at this point. So all that would apply right now to a landlord and project-based subsidy would be the CARES Act, which simply requires a 30-day notice. And if the tenant doesn't move in those 30 days or cure the amount, then the landlord could file the eviction case. So I'm not sure if the question kind of assumes the landlord giving a notice for some conduct issue, and now the tenant owes rent, would they need to give a new notice? And if that's the question, then the landlord might have to do a new notice if the landlord would want to base the case on the new issue.
And a similar question, maybe, I think, is there any specific content that needs to be included in a CARES 30-day notice?
Nope. The CARES Act doesn't have any content requirement, but if you are in a HUD subsidized housing program, you may have content requirements elsewhere. So for instance, for a HUD subsidized project under Manual 4350.3, I know that's getting way in the weeds, but if you have those kinds of properties, you know what I'm talking about. There are requirements in that notice. For instance, the right to ask for a meeting with management to discuss what the landlord's alleging. So that is a content requirement specific to the program. All the CARES Act did is really extend the time period for any notice that was given in a subsidized housing program out to 30 days, but then also extended that 30-day requirement to properties with federally backed mortgages.
All right, thanks, Larry. Former homeliner Alicia asked or mentions a common issue that I've seen in regards to notices is that landlords deliver notices to tenants by sliding it under the door. Would that be considered hand delivered?
My opinion on that is certainly no. While this doesn't fit the same procedural requirements for serving a summons and complaint, in other words, it's not you don't have to hire a process server. Hand delivered is still going to mean hand delivered. You got to hand it to someone. Larry, do you have any thoughts that are different from that?
No, I don't. The specific language is the landlord must deliver the notice personally. And so I could see how someone might be saying, okay, well, the landlord is delivering it, so she's doing it personally. That's not what that concept means in the law. When you're talking about serving a notice personally, it means received personally. And so what this law says is either delivered personally or by first-class mail. And so my advice to a landlord is, sure, if you wanna, if you're the manager in the property and you just want to go up to the second floor in apartment 15 and deliver it, fine. And if the tenant's there, then you've saved yourself a first-class stamp. If you don't do that, I think sliding it under the door is going to get you into trouble. Much safer to just go back down, put a first-class stamp on it, and mail it.
All right, thank you. All right, next, a couple comments. EA and EJ have been running out, but the changes to the financial information up front is fantastic. And another person saying it'll cut down an administrative burden. Sounds like a landlord is saying that they get constantly getting requests from county and assistance program to do verification. So that's good to hear. Is there a way to determine whether a property is covered by the CARES Act or has a federally backed mortgage without discovery from landlord?
Yes. So the link that I had on the slide to my manual has a section with some links on how to figure out if a property is federally backed. And again, if you don't have the slideshow, I mean, if you have this slideshow and you'll be able to get access to it when we're done, you can simply click on this link and it'll take you to that section. But if you don't, if you just go to, my website, povertylaw.homestead.com, and you go down to housing and you go to, and there are links that'll take you there. And once you open up that document, there's a quick finder at the top of it. And one of the very first items there is the CARES Act that takes you there. And I've got a number of links to websites around the country that help you identify if a mortgage is federally backed or not. If you're on the tenant side, if you're on the landlord side, take a look at your mortgage.
All right. A follow-up question on the notice under the door. What about taping to the door?
Well, I kind of feel like no offense, but I kind of feel like we're dancing on the head of a pin right now. I mean, there's no court decision on this specific language in this specific statute because it hasn't gone into effect yet. But there are a number of notice requirements and subsidized housing programs that have a method of delivery listed. And when there's a method of delivery there, the smart thing I'd say on the landlord side is don't try to navigate yourself into exception that might not exist. And my interpretation of this, and I'm not interpreting this just to be hard on landlords, I'm interpreting this conservatively. Because if I were advising a landlord, I want to say, this is what you need to do to not get into trouble. Okay. And when I look at this, I'd say, do a hand delivery to the tenant. And if you can't do it, just suck it up and put on a first-class stamp and mail it. Or, if that was 3 in the afternoon, then maybe go back at 6 o'clock at night. and see, okay, now the tenant's there, and now you saved yourself the stamp. I think for a lot of landlords, mailing it's probably just going to be more efficient than if you've got several tenants in different buildings that are behind on the rent, and you want to give the 14-day notice to all of them. It's probably going to be a lot more efficient to put them in the mail than to drive around to all the tenants.
All right. Thank you, Larry. The two, I think, fairly related questions. Is the pre-filing notice valid at any point after the relevant waiting period? For example, landlord files 4 to 5 months after the 30-day notice, or landlord files a case based on the same facts after dismissal without prejudice. When is a landlord required to provide a new pre-filing notice if an eviction is not filed after 30 days? And then the relevant question from Joe, what happens if a 14-day notice crosses over into a new month of rent?
I think the question from Joe is sort of the answer to the other question, which is the notice is good, in a sense forever, but presumably the facts are going to change if you wait too long as the landlord. So if you give the 14-day notice for rent, and the rent at that point is $1,000, and then 3 months later you file an eviction, well, you can only file for that $1,000. If there's been more rent due since that time, there need to be a new notice to let the tenant know that more rent was due.
All right. I think you maybe answered this one already, but could a landlord just have one big master notice and give 30 days to everyone, no matter what city?
Sure. Larry, I think that was your point, is that's what you actually would do.
Yeah. And Kim is mentioning that the city of Minneapolis actually has a sample 14-day letter that complies with their requirements. I'm not sure. I was trying to find that on the website. If we find it, we'll put it in the chat. Ruth is asking if we and these are, I think, community members, advocates who are visiting a tenant who's had an eviction filed against them, should they always tell them to ask for legal aid in case they have a defense?
I mean, I think, and this is obviously not always possible, but you always want to seek legal advice. I mean, this is true for landlords as well. We're giving general advice here for things that are true generally, but facts can make things interesting or bring up weird nuances or combine different areas of law. And so, ideally every person would be represented, at least with the way we currently have our court system set up. But tenants should always seek legal advice if they can, legal aid, Volunteer Lawyers Network, Homeline, of course, and then there are many other places as well. I shouldn't say many. There are some other places as well, depending upon your location and the issue you're facing, that you might want to seek. But legal aid or Homeline are great places to start.
All right, thanks, Samuel. Peter has a question about, are there any accessibility protections or considerations with eviction notice or pre-eviction notice? For example, people who cannot read English or cannot read due to disability or language.
Not that I am aware of. Larry, are there any subsidized housing?
Yeah, there isn't anything in this new law, but tenants with disabilities and special needs have a right under both federal and state law to ask for reasonable accommodations from landlords. And so I think it would be a reasonable accommodation for a tenant to ask a landlord for a supplemental method of communication. So for instance, let's say the tenant gets a notice in writing and knows they've gotten a notice, but they can't read it because they're blind. And so they call up the landlord and say, can someone read this to me? And if the landlord says no, that's potentially a denial of a request of what I would think would be a reasonable accommodation based on disability. And if the landlord said no, and then you know, and then proceeds with the eviction case. It would be up to the court to decide, was that denial of reasonable accommodation a kind of valid claim for dismissing the case? The argument on the other side might be, well, you know, the tenant could have asked somebody else to read it to him or her. And so maybe it wasn't really reasonable to ask the staff member to do it. I think it probably would potentially be an unreasonable request to ask the landlord to produce one in Braille. I don't know how expensive it is to translate a document from typewritten into Braille. So I haven't, if I were on the landlord side and I got that call from the tenant, I'd say, sure, I'd be happy to read it to you. I'm not trying to cause you any trouble.
Other examples of reasonable accommodations that we've seen like this are asking for an electronic version. So the statute doesn't require it, but a tenant, for example, who can read but needs it to be very large, or who might want it electronically so it can be translated to another language, I think could make a reasonable accommodation to have it in electronic versions. And we've seen reasonable accommodations to send the notice to someone else. So the tenant may still have to get it, but maybe they have someone who isn't technically a guardian, or someone who would maybe have a legal right to it, but who the tenant wants to get a copy of it. And the tenant can say, as a reasonable accommodation, send this notice, not just to me, but to whoever that other person may be.
All right, thank you. Just a couple of minutes left here, so we're going to try to capture one or two more. One question about, could you put in the notice, could a landlord put in the notice that the rent due is an X specific amount, but that it'll be an increased amount after the first of the following month, and then file the eviction for the larger amount?
I'm actually not too concerned about this being something where the courts are going to try to say gotcha on this. I mean, right now, so let's say I give a 14-day notice. Right now, we're in September, and then I kick over into the next month. Do I have to file a brand new notice to kind of cover that next month? I'm guessing the courts are going to say, you're okay. You filed, you gave this notice, now I think it makes more sense to give the notice earlier in the month, right? So let's say you give the notice on September 10, and then, nothing gets resolved. And so then you file your eviction case on the 25th. And so you base it on the amount that's in the notice. Well, right now, the courts have the power to say at the time of redemption that if McDonough actually owes another month's rent because of where the court case is now sitting in the calendar, that the court can order McDonough to pay that additional amount on top, even though that wasn't what was listed in the notice that was given in September. So I don't think the courts are gonna kind of play games with landlords on that. Because the courts have that power to say at the time of determining what's owed, we look at what's actually owed. Now, I think for the landlord who sits on it for months, I could see the court saying, well, you kind of led this tenant to believe that things were done. And so I could see a court 4 months down the road saying, wait a minute, you should have given another notice. Because the whole idea of this really is to say, tenant, things matter on this issue. You need to address it right now, either in terms of, are you going to stay? Are you going to go? Are you going to get emergency assistance? Things like that. And if the landlord sits on it for months, it's kind of lost the quality of that.
All right. Well, we're hitting 3 o'clock, and so we're gonna call it a day. I think I want to thank Larry and Samuel for the wonderful presentation and fielding all these questions. Just a reminder again, these are free public webinars. We want to make sure that everybody's educated about these issues. We're going to continue this series. And there were a number of questions about some of the other new laws, particularly about heat. And so coming up in the next month in October, Rachel Sterling and Matt Eichenlaub, housing attorneys at Homeline, are going to be talking about heat, emergency repairs, privacy, and the break lease due to infirmity. Those law changes. In November, on November 15th, Steve Rathke and Larry McDonough are going to be talking about expungements and evictions in the public record. In December, it's the Larry show. He'll be talking about the changes to the eviction process, as well as the new public right to counsel in public housing cases. And then in January, we're going to have folks from the Minnesota Budget Project to talk about the changes to the Minnesota Renters Credit Program, which go into effect for rent paid in 2024. So it's taxes in 2025. The big deal there is that renters credit change is going to be going into the income tax forms rather than a separate property tax form. So lots more content. Again, recording of today's session will be up on our website, as well as the materials, the slides. We are going to apply for CLE credit, and everybody who has attended will get a follow-up email once it's approved for CLE credit. Again, thanks for joining us, and I think that's all for today. Thank you very much. See you later. Goodbye.